Hello, I'm Rick Cook, and it's my pleasure as LAI Land Economic Society Regional Vice President for Western North America and a member of our Vancouver LAI chapter to introduce today's webinar on a topic that has been on our organization's radar for years, housing affordability and the role of construction defect law. Why, I asked, as we researched a talk in April 2023 on missing housing, does California build so few multifamily housing ownership units, something like 3% of total dwelling starts, while in Canada it's been one of the most common forms of housing, around 38% of annual. At the time, I recall our moderator from UC Berkeley's Turner Center quipped something like, I don't know, but if you can figure out a solution to construction defect liability, please let me know. We took up that challenge and we produced several events focused on both encouraging ownership multifamily housing and the role of practices that created hurdles, like differences in construction defect practices and consumer deposits between regions where LAI has chapters. And we'll provide you links to those resources later. LAI is an honorary society that connects land economics professionals from around the world. Our 2,000 members share knowledge, exchange ideas, and advance best practices related to the use and reuse of land. Local chapters are found in major cities throughout the US, Canada, Europe, and India, including 5 chapters in California. On October 8th to 10th, we will host our annual Land Economics Gathering in Honolulu. One of today's speakers, Tim Hutter, is a member of our San Diego chapter. A sister organization, the Land Economics Foundation, sponsors academic and professional research on land economics topics. Our moderator today, Thomas Gonzalez, is a VP of Economic and Planning Systems, and he's participated in one of those research efforts. In that research and in these webinars, we aspire to these principles: curiosity, valuing facts, scholarship, research, practical experience, professional ethics, and I think most of all, the courage to listen to different points of view from different places, from different professions and different life experiences. And in that spirit, we hope you'll enjoy today's webinar on where legislation to support housing delivery might take us, not only in California, but potentially many other states. An outstanding panel has been assembled, and support of this initiative has attracted interest from a wide variety of sponsors: the California Building Industry Association, the Bay Area Council of Infill Builders, Habitat for Humanity, Housing Action Coalition, and SPUR. At LAI, we welcome your comments and ideas for future events on this or any other topic. Related to this topic, I'm pleased to announce that one of the bill sponsors, SPUR, will be hosting a webinar on Bill AB 1903 on May 7th from noon to 1 Pacific time. It's free, and you'll hear more about this from Michael Lane at the end of this session, and you can register for it when it's up at spur.org. Thomas, over to you.
Thanks, Rick. Glad to be here with everyone today. My name is Thomas Gonzalez, and I am, as you mentioned, I'm Vice President with Economic and Planning Systems, land use economics firm, and I'm located in Los Angeles. And I wanted to start off before we jump into the panel, providing a little bit of framing on this topic. Some of you may be very familiar with the construction defect liability, but I'm gonna share a few slides here, and to bring that up. All right. So why are we here? California really produces a fairly pitiful number of condos. I think it's around 1,500 per year lately statewide. That's only 2 to 3% of all multifamily buildings. As Rick mentioned, Canada does a lot better. They build about 40% of their multifamily projects as condo, and they actually produce more multifamily projects in general as a percentage of housing. In the US, New York, Florida, Hawaii are ahead of California. They're all in the 10 to 20% range. 10 to 20% of their multifamily buildings are condos. And you can see an example of that outcome of that here on the right. In Hawaii, nearly 40% of multifamily units in large buildings are owned, whereas that number is 10% in California. It's worth noting it's very hard to find historical data on condo production in California. I found an old LA Times annual survey of residential building noting that in 1985, 22.5% of all Southern California homes built were condos. That number dropped to 13.3% in 1986, and they actually had the amount, it was 9,154 units. And if you look at this data from the Turner Center, which is about as far back as we could get good data for LA and Orange counties, they haven't produced that much in a year in the last 20 years. So, what's going on here? A couple key dates to think about. 2002, the Right to Repair Act, which governs construction defect law and liability in the state, was passed, which was meant to deal with a lot of issues from that had come about in the 80s and 90s. We might hear a little bit more about that during the panel, but it was really 2007 when the Great Recession hit that we saw um, condo production drop off. And I was actually catching up on the UCLA Housing Podcast episode on condo production last night, and they were noting that that it takes about 8 to 10 years for the condo or construction defect law to kind of shake out, and that's part of the reason why we probably didn't see a recovery in housing production. Even the last few years, condo production has been about the same as it was at the low point, whereas housing overall in California has recovered to almost 3 times its production at the low point of the recession. So condo production really has dropped off in particular. My firm was hired by Turner Center and Spur to do some research into the exact financial kind of underpinnings of that and try to quantify what the costs are associated with construction defect liability. We did our best. There's also very little data on construction defect litigation, settlements, and insurance policies. It's very, very difficult to get all this data, but we interviewed a lot of experts and we came up with an estimate of 1.9% to 4.4% of hard costs, which may not be a tremendous amount, but it's I would say it's similar to what you see in impact fees. And I know the developer that I used to work for would compare different jurisdictions on their impact fees, knowing that they'd rather do a project in a city with lower impact fees. So maybe certainly enough to push things on the margin. And it comes from a combination of actual insurance cost, but also markup on architecture and engineering. And I would say a lot of architects and engineers we heard don't actually take condo projects. And I think the same is true, or there can be difficulties in coming to agreement with contractors and subcontractors when it comes to all of the complexity and limitations on insurance. So there's a lot going on here that impacts projects, and I think our panelists can speak to that. And then why do we care about all this? Well, California has a severe housing shortage and affordability crisis. And you can see in this map, we're at the bottom along with New York in terms of home ownership rates in the US, about 55%. And if you look on the right here, condos typically cost a lot less than other types of homes. So they could be a really accessible price point for new homeowners in the state. And I know that's why the Turner Center and others have been really interested in this topic. And if we, that's sort of how we ended up here today looking at Assembly Bill 1903. This legislation was introduced by Assemblymember Buffy Wicks, and the goals are really to strengthen the right to repair, which was the intention of the original act in 2002, but we'll hear about how that's working. And then to ensure claims really involve actual damage, encourage repair instead of litigation, and generally increase transparency in HOA litigation. Rick mentioned the sponsors of the bill. There's quite a few organizations, and a lot more have signed on as supporters. And I'm really excited to kick off this conversation. I'm personally very interested to learn about this bill because I'd love to perhaps buy a condo one day. So, with no further ado, I will introduce our panel. All right. Today I'm joined by Nick Camarota, who's a senior vice president and general counsel with the California Building Industry Association. And Nick also, before that, worked for the BIA of Southern California and is an attorney. So he's got a lot of experience on this topic. And we're also joined by Tim Hutter, who's a partner with Alan Matkins. He was a past president of LAI in the San Diego chapter. So great to have him with us. Tim leads his firm's construction practice group, so deals with quite a bit in related to construction projects and representing owners and developers related to construction defect law. And then we're joined by Stephen Harrell, who is a managing director with Totalis Program Underwriters and Insurance Specialty Group. Since joining Insurance Specialty Group in 2010, Stephen has overseen all underwriting and operational activities for that firm and has been involved in insurance underwriting for quite a few condo projects. And I know he has a lot of experience, particularly um, around the nuances of warranties and other types of products and efforts that have been used over the years to try to manage risk and insurance in condo production. And lastly, we've got Mia Kang, who is the chairman of the Council of Infill Builders, one of the bill sponsors, and which CBIA is as well. Um, Mia has more than 25 years of experience as a developer and policy leader here in California. So glad to have her joining us as well. All right, I'm gonna kick it off by asking our panelists to help paint a picture for guests today in terms of where the current system is breaking down when it comes to construction defect liability and defect law in the production of condos specifically. Tim, I'm going to hand it over to you.
Thanks, Thomas, and good afternoon, everybody. I'm Tim Hutter. I'm a litigation and land use partner at Allen Matkins. I'm based out of our San Diego office. Frequently represent owners and developers in construction litigation, including serving as personal or monitoring counsel for clients who receive SB 800 notices. So I work in this area quite frequently. I'll confess, I have occasionally sent an SB 800 notice on behalf of a client who wanted to be a plaintiff on some construction, but typically on the defense side and working with our owner developer clients. I was asked to give kind of an overview for the SB 800 process, and so I'll kind of give a comparison and contrast of maybe how it was designed as compared to how it's actually functioning. And we have some great panelists on the team who are going to be able to talk a little bit about kind of how did we get here and how we might be able to put forward some solutions. So the SB 800 process as designed in the simplest form is a homeowner buys a house from a developer. They are living in the house. They see a problem. They identify it, right? Their window is leaking. They notify the builder about that. The builder's given an opportunity to investigate the problem, evaluate a repair or a cash payment, request a meeting, and ultimately make a proposal either for a repair solution or a cash settlement. The entire process for SB 800 is intended to play out over about 90 to 120 days, with some opportunities for short extensions if you want a second inspection, alternative contractors to be involved in the repair process, or mediation. What ends up happening, and the way that this is kind of morphed into a larger process, is that at some point in the year 3 through 10, or year 3 through 9 after the building is constructed or the neighborhood's constructed, a lawyer gives a presentation to the HOA board about what are all the problems that could be happening in your neighborhood, right? The type of construction that you have, whether it's a condo building or a single family home neighborhood. These are the types of things that may be happening and that you and your neighbor should be on the lookout for. Sometimes if the HOA board isn't fully functioning, or right, if in certain situations, they'll go directly to individual homeowners, identifying potential problems that may arise in your home. And the list of potential problems that you would see in this presentation or in this solicitation would be concrete cracking, window leaks, plumbing leaks, drywall cracks, essentially anything that could go wrong with a single family home or condo. In the best of situations, those lists are generated based on actual complaints that have been observed in the community. In other scenarios, the list is based on common complaints in similar units or similar complexes that have been generated by that plaintiff's attorney or their expert team over years of experience. Another fun fact, I live in a neighborhood that's about 10 years old, coming up on 10 years old. It was built by a large national home builder who happens to be a client of mine. And about 2 weeks ago, we got a letter in the mail from a law firm in the LA area suggesting that we might have defects in our home, that we are missing a huge opportunity if we don't sign on to their potential SB 800 claim. And so my wife, fished that out of the mail and handed it to me and said, "You deal with this." So it's everywhere, and there's often not a lot of investigation that goes into it, right? It's a pure solicitation. So after you get that notice out, or after the solicitation goes out, you have a group of either a group of homeowners or more often an HOA board that is bringing and sending a notice through their attorneys. The list of issues is numerous. It's gigantic. Like I said, it usually includes everything that could be going wrong in the community. Sometimes it's based on actual observations, of defects that have been noted in the community. But the list is so numerous that the opportunity for serious investigation in the time period allotted under the statute is really impossible, right? The developer receives that notice, sends it to their lawyer, enter Tim, who advises that they tender that to their insurance company, that they notify their contractor, and unfortunately, the time that it takes to go through all that process, it's very rare that everybody has their ducks in a row lined up, even when we act quickly, to get into the SB 800 process and comply with this 90 to 120 day period. In fact, the statute says you have 14 days after receipt to acknowledge the existence of the claim. And if you don't act that quickly, then you can waive your rights, right? So at each point, there's off ramps where you can lose your right, quote unquote, right to repair if you are not complying with the statute. So there's some procedural hurdles that are built into this that make it very difficult in the way that it operates today. Again, I said a big component of this is the insurance company's involvement, right? When builders who are brave enough to build single family or especially condo units in California, they are making sure that before they start that process, they are heavily insured. They're protecting the community by creating and their investment in the community by procuring this insurance. The insurance industry is misaligned with the SB 800 process, and there's a couple reasons for that. One is that the insurance companies don't pay for defective construction. They pay for the resulting damage that comes from that defective construction. But SB 800 doesn't require resulting damage. SB 800 only requires that you have something that was built improperly. So if a pipe is not properly sloped, it's behind your wall, but it hasn't leaked yet, it is an SB 800 defect that is not insured in the strictest case. And you have a disconnect there. Oftentimes, my clients' insurance companies are saying, well, it's all well and good that you're receiving this long list of defects, but it's not necessarily the case that your insurance policy is going to cover all those things. So the disconnect with insurance is one big problem. Another is what I would call the extrapolation problem, right? Because of the way that these lists are generated and the way that the plaintiff group is constructed, you oftentimes have costs of repair provided by plaintiff's attorneys that are not generated based on the cost to repair observed problems. They're generated based on what it would cost to fix the problem if it exists in many more locations based on a probability or a percentage uh, based on their limited investigation. So that's another one. And the third thing that I would identify as a big problem, and I know Nick and others are going to have additional comments here, but the third thing that really I think needs to be fixed is that there is no release provided for the builder, developer, or the insurance company if you perform the repairs. So insurance companies like releases. They like a clean break after they've invested money or put money forward, or if their insured has put money forward. They don't want continued exposure. So they're looking for a release. And if you're performing repairs to fix that window leak that the individual homeowner has seen in their home, you don't get one. So these are some of the structural issues that are built into this. And uh, one of the things that we're, I think, hoping to address as part of this process.
Thanks, Tim. Thanks for kicking us off. Sounds like there's procedural issues. There's, challenges with the way that liability is constructed related to damages versus not. And there's that lack of release. Even if a repair is done, in theory, I think you can still be sued again at a later date for that same repair issue. So all sound like problems. Nick, do you want to add to that and talk about how that's affecting home builders and developers?
Sure. I guess let me begin by saying that we want to fix real problems, but we don't want to be exposed to liability for defects that don't exist and have never existed. If you were to think about how you operate in your own home, you are the occupant and you would notice if there were a problem. If you have a leak, usually there's some visible or observable evidence of that. If a faucet doesn't have water running out of it when you turn it on, same thing. You know that there's a problem. The overwhelming majority of the claims that our members, builders, are seeing are ones for which there is no evidence of a problem. And that arises in part because our customers are not using the normal customer service that is provided that can occur to resolve real problems before they enter this more formal pre-litigation procedure that Tim was mentioning. The first notice we have that our customer has a problem is from the notice of commencement of legal proceedings and the notice of claim that we receive signed only by a lawyer purporting to represent some homeowners. And they very often don't include any evidence of the claim. They just cut and paste the definition of defects from the statute. And now begins the problem that we have of proving that defects don't exist. We have sworn declarations under penalty of perjury by many homeowners who indicate that they did not know that they were involved in a claim or a lawsuit, that they have been asking their lawyer to provide them with evidence of their defects. They don't know what defects are being claimed or the cost to repair those defects. And when they ask for that information, their lawyer is threatening them with abandoning them as a client, withdrawing from representing them. And I think that I'd like to say that that rarely happens, but the lawyer is not speaking with his client. And I'll just mention that one of the things that SB 800 did was prevent us as builders from speaking directly to the homeowner so that we could resolve these problems. Once their counsel is involved, the counsel is trying to get them into court, not to repair. And most people, when they have a real problem, want it fixed. They don't want 2 to 5 years of litigation, which is what their other alternative is. So I think when we face these issues and we see these repair cost estimates, especially for condos, because there are common walls and common roofs that HOAs are required um, to repair or replace or maintain. Um, that those costs of repairs are in the $10 million range, let's say, for a repair that might actually cost $2 million. Once it gets into that stage of the process, you're now seeing lots of inflated claims, claims for which there is no damage that actually exists today, and they don't have to prove that there is damage. If you have a car accident, for example, you have damage to a car. If you have personal injury, you have those are documented types of damages. And I think one of the issues here for AB 1903 is to fix that problem by making sure, for the most part, that the functionality standards or the defined defects contain a requirement to prove that there's some damage to or resulting damage, as Tim put it, to another component part of the house, so that you're not dealing with something that is made up or might happen at some point in the future, 10 years from now, 20 years from now, etc. So I think that having that will be important. We recognize that fire and life safety issues may be a special circumstance in that situation, but even there, claiming that someday something may happen here is going to need to be tightened up in some way, so that we're separating out the real defects from those that I'll just politely say are unreal. Um, uh, Thomas, you look like you were going to say
I
something.
was gonna ask you, Tim kind of spoke to the typical process that has evolved where attorneys are approaching HOAs, kind of, across the board. And I wanted to ask you or Tim, what percentage of new homes and maybe condos, if you know that, do you think are ending up with these, you know, litigation actions or claims being brought?
Um, I'm going to say I don't have anything other than anecdotal evidence on that. But I think that the proof is in the pudding. You saw that the decline in condo production. I've seen other numbers that indicate that in I want to say roughly 2007, we had produced 27% of our production was condos. And in 2007, it was 3 to 4%. I realize that overall starts may fluctuate. So we're doing this as a percentage of the start for those years. So that severe decline is a result of our members now, when they look at a multifamily site, are, as part of their underwriting, looking at what they're going to face in terms of losses in building that product. And if I have to go out and do $40 million of repairs, and that's part of my costs, and whether those are insured or not, very often they're not insured. It doesn't make sense economically for them to build that project. And they're factoring in things like the frequency of those lawsuits. So if that's 50% of them or 75% of them, that all gets put into the mix. And that, I think, is why developers are choosing not to build this type of product. It is just upside down. And I would say that over the last 5 or 6 years, those costs have dramatically increased. And I'm sure folks will have some information. I know we saw some on insurance, but I think that will be reflected in those numbers.
Yeah, great. Yeah, and it sounds like costs have gone up, and the other thing I heard you say is that bottom line, we've moved to this system where most developers are receiving letters from lawyers rather than calls from homeowners about actual issues. And these letters are so kind of formulaic and difficult to respond to that they make it hard to actually use the right to repair process that was intended, that old legislation. But you talked about costs, and you mentioned insurance. So I'm going to turn it over to Stephen because he's the guy that can talk to us about what is this cost of developer on the insurance side. And Stephen, I'll let you weigh in on what the where the current system is breaking down.
Yeah, thank you, Thomas, and appreciate the opportunity to join today's webinar. Just for a little context, Insurance Specialty Group is an underwriting entity that specializes in insurance for residential construction around the United States. And our focused geographic areas are really states that have historically been tougher states from a construction defect standpoint. So the company has been underwriting residential construction for over 25 years. And throughout that entire period, California has been our largest state where we deploy our capacity. Other states that fall into that category are Colorado, Florida, somewhat in the Pacific Northwest, South Carolina. If you follow construction defect law around the U.S., you would know that those are some of the tougher construction defect states. We have underwritten about 1.5, 1.6 billion in premium around the U.S. Like I said, the majority of that, over 30%, has come from California. And when you look at residential construction as a class of business from an underwriting perspective and insurance profitability, it is widely known as one of the toughest classes of business to profitably underwrite. And when you start to zoom in on where the losses come from in this construction segment, it is largely multifamily coming out of Colorado, and you can find somebody at every single insurance company in the world that has tried to underwrite residential construction and has done so with massive losses that heavily outweigh the premium that was collected. So focusing back on, California, what we have seen over the last 25 years and really focusing on the last 15 from a profitability perspective is that the majority of carriers underwriting tract home construction, multifamily construction, and to the furthest extent, condominium construction in California have not been able to generate profits. And it's really stemming from construction that came after the recession, so starting in 2013, starting to get construction back going again. And as Tim and Nick commented, letting the time elapse so that we start to see the losses that come from these projects. It does take time to get to those. But ultimately, the class has produced unprofitable results in California. And given that construction in California has been a difficult litigation environment for a very long time, we find that the builders in California are oftentimes more sophisticated around their risk management and quality controls than what we would see in other states. And that's really, just been through lessons learned on how difficult it is to defend construction defect lawsuits. And so where we are today is when we deploy our capacity, particularly on condominium projects, we are requiring to have third-party vendors out on the job site every 30 days looking at the quality of construction. And with the data that we could collect from that, I can confidently say the quality of construction that we see in California is really superior to what is seen throughout the rest of the United States. Yet the losses that we see from California are worse than the rest of the United States. So this is really not a quality of construction issue. It really gets back to how claims are monetized in the state of California. And the frequency of claims that we see on condominium, Thomas, to your question, is around 20 to 25% of the projects that we have insured in California have seen construction defect claims presented on them. The majority of those claims are, Nick, trying to think of your term, really not true construction defect claims where we are seeing actual property damage resulting from poor quality of construction. It is a list of defects that is very, very complex that has been presented to the builder. Oftentimes, Nick, like you said, we have homeowners that are not even aware that there is a defect that has been filed on their unit or their home. And they're very, very complex in order to really get away from SB 800, right to repair. We have a problem, it's identified, let's get the problem corrected, and let's go back to living in the home. So, this is not about trying to deny claims. It's about reducing the frictional costs around claims. And ultimately, the difference in the profitability of California construction insurance versus other states is defense costs. And what the current system, unfortunately, has allowed is that fee-driven litigation models are supported through it, and getting a house fixed through the right to repair laws, really doesn't produce the results that this fee-driven model is able to support. So fixing the home has not become part of the issue. If we can get insurance dollars back to just fixing the home and taking care of the homeowner's investment, then it would be an incredibly easy state to insure. It's controlling defense costs that really we've got to get our arms around. And we've talked a little bit about the costs that it is placed on a project in order to buy liability insurance. And if you look at a condominium project, say with 50 units, construction costs around $325,000 a unit, that puts you around 16 million, 17 million in costs on the project. For a project like that, it would be covered under a wrap-up insurance policy. You'd probably need a 3-year term to get that project, out of the ground, completed and sold. An appropriate limit on that project would be around $7 million, I would say, or more from an insurance perspective. And the cost to buy that limit in today's market will be over $1 million. And that's the cost if the insured had the insured being the builder developer, a relatively low retention. So maybe a $25,000 retention. What we are seeing is that is well more than doubled in the last 10 years. So in order to offset some of those costs, the builders and developers are forced to take much higher retentions. So instead of that $25,000 retention, we're seeing builders forced to have $100,000 or $250,000 retention. But that cost of, say, $1 million for insurance is there based on claims activity that the industry feels is necessary to support the limit that's being deployed. So whether it's being spent in insurance dollars or whether it's being spent within a builder's self-insured retention really doesn't matter. But that shows you the amount of money that has to be built into a project, over $1 million on a $17 million condo project, there to fund insurance. And if you break that down to, back to 50 units, it could be $25,000 a unit that is put into the sales cost in order to cover insurance costs. If you put that in a mortgage, it's nearly $150 a month that the homeowner themselves is now paying to support the insurance to defend construction defect claims in the state of California. So if you look at other states that we insure all around the country, you'll see significantly reduced rates for multifamily construction. And the difference, like I said, is it's in the defense costs. And ultimately, the homeowner is there having to pay, for the cost of the building, for the cost of their insurance, and for the cost of the builder's insurance that is required to defend the claims that come in so frequently on California multifamily construction.
Thanks, Stephen. Interesting that you noted that to some degree the system has resulted in higher building quality, but that hasn't actually reduced in any way the amount of liability or cost associated with addressing defects that you, in theory, would go down as building quality goes up.
By the way, I would
note that our firm's underwriting approach has always been very heavily focused on risk management and loss control as the method to control both frequency and severity of claims. So, when we see an underwriting problem, we don't try to push rate as the first spot, and we don't try to reduce coverage. We try to help control that risk. And what we have seen in our book of business, and really what the industry has seen very widely in California, is an incredible requirement on third-party construction quality oversight. And through that, the insurance industry is out on these job sites at a very frequent rate, with licensed or degreed architects and engineers really acting as outsourced job site superintendents and monitoring this data back to us on a monthly basis for every single site that we insure, and us following through on any construction anomalies or concerns that are noted in these reports, feeding that information back to the builders, making sure that these items that are, noted as an open item are closed out. So there's really never been anything close to the level of oversight historically around quality that there is today. Yet, my firm in particular, we actually exited January of this year. We left underwriting condo construction, stacked multifamily construction in the state altogether, because we felt like rates are so high, we have so much quality oversight, yet we're still unable to produce profitable results in the state.
When was that?
That was just January of this year.
So as of January this year, you've stopped offering insurance on new condo projects in California.
Yes, we have. And to my knowledge, we are the largest or the longest standing underwriter of residential construction in the state of California.
Nick, you want to chime in?
Yeah, I just want to say the result of that dynamic of increased quality control and yet complete loss of profitability is an indication that most of these claims are not made in good faith. These are not real defects. And that comes from a variety of situations, but especially the definitions of the functionality standards, the definition of defects, the lack of damage, the ability to do investigations, as Tim mentioned, extrapolation of evidence, that investigations and destructive testing wind up either causing defects in the best scenario, or you extrapolate out a bunch of defects that don't actually exist. If I test 15 windows and half of them are, I can get them to leak through conditions that will never occur in the location of the project, then I can extrapolate that to 700 windows throughout the project.
Yep.
It's a system that facilitates unrealistic claims.
Well, let's talk about solutions then. I think you guys laid it out pretty well. And just to note, there will be time for Q&A from the audience towards the end of the webinar. Just wanted to note that you can put your questions in the chat, and we'll try to get those to panelists. But let's talk about AB 1903. You all have had a chance to review some of the information. Also for attendees, Sheila added a fact sheet and a link to the legislation itself, if anyone wants to check that out. I'll go back to Stephen, because you're not insuring these now. From what you know of AB 1903, what elements of this bill could potentially bring you guys back or change the way that you think about risk and pricing?
Yeah, I mean, there's a number of things in here that we really feel like are moving in the right direction. One of the items that jumped out to me first when I was reviewing the bill was the education and the notice requirements around joining a construction defect claim that would be provided to the homeowner, so that they understand there is an opportunity to join a construction defect claim. And what does that mean for you as a homeowner or unit owner in this community? There's a lot that needs to be considered before joining one of these actions. And if there is real construction defect that's existing in a home or in a condominium project, it makes the decision pretty clear that the builder needs to come back in, be held responsible for the quality of construction, and repair needs to be made. In the absence of the homeowner having concerns, having their knowledge expanded around the fact that if you join a construction defect suit through the right to repair laws, that has to be disclosed when a unit is sold. And you also have to disclose whether any repairs were made to your home or your unit as a result of that. And while you have a home that is in litigation, it really presents some concerning things to the unit owner in the fact that there's going to be a reduced pool for potential buyers. You're going to have a difficult time for potential buyers getting financing on that unit. So I think that education process helps the homeowners weigh the ability to say, do I want to participate in this or not? Do I feel like I really have damages in my home or my unit or not? And with that education, and then the bill requiring that 75% of the unit owners need to participate. So you've got, your super majority of unit owners saying, yes, we have an issue and we need to have this issue corrected within our community. I think right there, you really filter out where do you have concerning aspects of construction quality and where do you have aspects that maybe are more pushed through the process that's allowed now versus, a concern in this. So that's one of the pieces that we really, really like about this bill. There's aspects that really point to you have to have property damage that is resulting from the concerns that are noted in it. There's a lot of detail that needs to be provided that says these are our concerns. This is the property damage that's arising from it. And here's where in our building you can find these concerns, and having evidence of the actual location of these so that the builder has the ability to go back and address those concerns with the homeowner. So those are some things that we really, really like in the bill. It's very much a repair focused aspect that I think would be incredible in just focusing the insurance dollars on communities that have concerns from a quality perspective. And I think right there we would see, a lot more opportunities for insurers to come back into the state.
That's a great point, Stephen. I know that I heard an anecdote of someone who was unable to buy a condo because it was in litigation, had ongoing litigation, and a lot of folks don't realize that that's an impact of potentially signing on to a lawsuit. It affects you as a homeowner as well. It's not all, a great outcome. And I think one of the other things that came out in our research is that sometimes there's a disconnect where some of the largest settlements and litigation actions are actually not where there's the largest number of defects. So it's sort of that disconnect that you're pointing to, I think, a bit, and wanting to bring it back to dealing with real meaningful defects. Nick, you're a sponsor of the bill. Talk to us about how you think it's going to improve outcomes.
The courts have referred to this, and before the courts even took up the various legal issues in the bill, we were referring to this SB 800 as the Right to Repair Act for home builders, but the Right to Repair Act. Unfortunately, it has become anything but a right to repair. And I think first and foremost, what we need is a release for repairs. If we make repairs as we do today, and then get a lawsuit filed against us after the repairs have been made, who is going to do repairs? And that is a fundamental issue if you want repairs to be the remedy for a defect, which seems reasonable. But there are other folks who profit off of not doing that, and they're the ones who push people to litigation rather than repair. And I think that's a release is very important for that. I think the second item is the fact that unlike other areas where whether it's torts or breach of contract, that there is no damage component necessary for there to be a defect that is recoverable or valid, is a very serious problem with the current state of affairs, because convincing people that there may be a problem at some point in the future, even if there is nothing wrong today, people err on the side of caution, and they'll want some remedy for that. And I think that also, I will say, acts as a temptation to the claimant who is making the claim that they could benefit from getting some money for something that is not really an existing problem. And I think that's fundamentally indicated by the fact that if you pay money to a claimant, there is no requirement in the law that they spend the money on repairs. But I think damages is an essential portion of a remedy to fix, at least initially, that problem.
Well, the bill doesn't currently require that money is spent on repairs, does it?
It does not, but I'm just saying that is an identified problem,
Hmm.
and whether or not that is what the finished product. Obviously, it's a product. The bill is going through the process and may make some changes along the way. And uh, what the bill is intended to do is first address the biggest problems, but by no means all of the problems.
Great. Thanks, Nick. Mia, I want to hear from you. You've also been your organization is also a co-sponsor of the bill, and tell us a little about your perspective as a developer. What do you see the problem, and how do you see the AB 1903 addressing the issue?
Thanks, Thomas. Yeah, as an infill developer, most infill developers build rental product. Those stacked flats that Stephen talked about that he's exiting the market on. Those are frankly the least expensive option to build higher density housing at scale. 25 units to the acre plus. A lot of times you really are talking about stacked flats. A lot of times those are wood frame. Now, from the apartment perspective, we rarely sue each other. We just fix the problems. We build new construction, we fix them. The profile of the owners and the insurance are different. The incentive structure is not there. You don't have the HOAs involved. You don't have these plaintiffs' attorneys coming in. It's a very different regulatory structure. However, you're building really similar buildings. And from the high level of, Title 24, the changing of the building code, we have absolutely seen an evolution of what we're building as better buildings, from resiliency standpoint, from an energy standpoint. And we've also seen, years and years of making it easier to get housing approved, whether it's environmental, CEQA reform, exemptions, along with by right. And the various SB 79, SB 10s, and all the abilities for landowners and developers and builders to be able to get the entitlements they need to build the housing. Yet the only thing that really pencils is rental, because you can't afford the high cost of insurance. And so really what we're seeing now is, because of the signaling of many jurisdictions saying we want to see more housing, we're getting interest, we're getting people, we're getting developers to entitle projects, yet they're sitting there stalled. Because right now in this economy, cost of materials, high cost of construction, and it's hard to get financing. It's hard to get financing across the board. It's virtually impossible to get condos financed because you can't get the insurance on it. And really the only thing that you could build on a condo market is really the luxury end product, something that you're going to see in a tall concrete and steel building, something that's, certain markets like a San Diego, LA area and San Francisco will see. Outside of that, kind of the missing middle piece that in many cases, I think legislators and policy experts all agree that if we can bring more ownership housing in these transit-rich areas, infill areas, we're going to start to be able to deliver, hopefully, a more attainable level of for sale ownership if we can start to remove the incentives that make it a disincentive to build condos. Because under most circumstances, you're most likely to be sued, and everybody has to underwrite the fact that you're going to be sued if you're going to do a condo. So it doesn't incentivize the market to take the risk. We're not getting the kind of housing production where, frankly, when we're also looking at condominium ownership housing, because you're able to deliver those at scale, potentially, you're also going to be able to deliver those hopefully at a lower price point at the end of the day, where we can start to really begin to see some of the other mechanisms we're talking about. Even when it comes to infrastructure, when you're going into infill areas, infrastructure is one of the really challenging things to sort of have to accommodate, especially that first 50 unit project out of the gate. You could really begin to work with local governments to look at condominiums as being part of, or new for sale being part of a tax increment strategy around being able to finance infrastructure and enhanced infrastructure finance districts, for example. But if you've got a bunch of stalled projects that have the potential to be housing, yet no mechanism to get them to be housing, really, you're not seeing any growth. So, one of the reasons why we're involved in this bill and one of the co-sponsors is because, we know that rental is not working and is not the only solution. And if we don't get more for sale ownership housing into California, like we've seen with ADUs and the proponents of ADU construction, where you have homeowners or landowners that have land and have the ability to do a couple more units, have the ability to do a condominium and now sell those ADUs or sell those units, we can really begin to see a market that can start to shift and see delivery at multiple scales. And I think, we need a system where risk is predictable, where repairs actually lead to closure. And AB 1903 begins to get to that, and we can begin to signal to everyone involved that you can invest in California and hopefully get housing and not just a guaranteed lawsuit.
Thanks, Mia. Um, well, I think Stephen, when I, asked you about kind of what bring you guys back, you were highlighting, I think the claim process and the HOA, some of the HOA notice items. Nick, you were out highlighting the item around damages and encouraging repairs. And I wanted to go back to Tim because I know Tim's sort of involved in the nitty-gritty of all this when these claims are coming through. And I want to hear your perspective on how how legal and procedural changes can potentially improve this process and affect behavior in terms of how HOAs are going about addressing construction defects.
Yeah, so I think, Nick had touched on a couple of these items, but, verification from a unit owner, if your unit's going to be involved in litigation, that you've observed these things is a big part of this, right? It will require a little bit more skin in the game. It will make people think about, hey, now I'm getting myself involved in a lawsuit. Most people, for better or for worse, don't like dealing with lawyers. And so if they're signing up and having to, it's much easier for a lawyer to knock on your door and say, hey, we're going to go fight this lawsuit, and we may have to come in and have somebody look in your unit at some point, but you don't really need to do anything. Just sit back and then we'll come back and we'll go get a check for the HOA. That's a different experience than you, the individual, need to fill out this form and explain what's wrong with your home, be prepared to let people into your home, right? I think often that's maybe an overlooked part, right? I can just say from having scheduled or been involved in the scheduling of individual unit inspections, the amount of distaste for an individual condo owner who lives in a high-rise condominium and has to have 14 people traipsing through their unit, right? We can wear booties or we can do all the things to protect their flooring, but nobody likes to have that invasion of privacy. And if it's part of what they have to go through up front, they might not choose to do it. So I think the verification is a big piece. I think also, if we can track it to real damage and real observed problems as opposed to extrapolation by a team of experts,
And
that will really help
is the bill going to
because it
cut
will.
down on the number of folks traipsing through apartments?
What's that?
Is the bill going to cut down on the number of folks traipsing through apartments? How do we make that happen?
No, I mean, my point is that I think if people knew that that was part of the process, they might be less likely to sign up. Because really what we're talking about, and maybe the other way to do that is that there will be some reduction. One of the things that's proposed, at least, is to reduce the recovery of investigation fees, right? So when an outside consultant is working with a legal team, part of what they put together is, hey, here's my plan for how I'm going to go find or create, in some cases, a series of defects that then we can we can discover them, and then we can come up with a plan for how we're going to fix them. And the water testing that can be involved, especially in, high-rise glass buildings, right? You're creating gale force winds, type 5 hurricane type water and wind events that would never happen in San Diego or San Francisco or LA or wherever else. But that's the type of condition that you put these buildings through in order to figure out if they might leak under those conditions. So I think those are all big things that currently exist in the system, and that if 1903 were to go through, you have some real potential to limit that, and again taper it back to more what we would call observable problems in normal circumstances, opposed to sort of laboratory conditions.
Yeah, I think you had said in our planning call that there's more consultants out there telling you what repairs you need than there are contractors actually making repairs because of the incentives around this investigative, uh, um, you know,
Yeah, I think that's a good summary. I mean, and this goes also to the point that I think a couple people had made, which is what happens with that money after the lawsuit's over, right? And one of the proposals, at least that we've kicked around as a group, is could we create a data tracking element, right, as part of future litigation? If we're able to succeed in this process, or frankly, if things come up short, maybe one of the things that we need to demonstrate and to some of the opponents of this bill would be a some data collection showing that, hey, out of $100 million, or however much money the insurance industry ends up paying out in claims recovery, it's significantly north of 100 million, right? 100 billion probably, whatever it may be, whatever that number is. How much of that is going back into repair work um, performed by an HOA? How much of it is going into HA reserves? How much of it is going to lawyers, consultants, all those sorts of things? And if you had those breakdowns, I think those numbers would be pretty stark, and it may be valuable for the legislature to hear it, or see that data.
yeah, it would be great to have more data. Question for you, Tim and Stephen. If this bill passes and is successful, how long will it take for this to, improve legal outcomes and insurance outcomes?
Stephen, what
Sure,
do
I
you think
can
it's going
jump
to take
in
for the
there.
insurance side? Yeah.
I mean, it's an interesting question. I think we're very much at a critical part of building from an insurance perspective. If you look at where the insurance industry that supports residential construction has ended up, it's you look at tract home construction. Many insurers writing residential construction in California have tract home limitations or exclusions, and nearly every insurer has a condominium exclusion. So what's happened is it has forced these tract home projects and multifamily projects to be insured under a wrap-up policy. And it's because you can't get good insurance elsewhere. And it's because the quality of insurance that the subcontractors can obtain has really been declining significantly over the last 10 years. So the insurers of a home builder are saying, well, I can't just write the home builder and then downstream to a subcontractor because there's not good insurance there to subrogate against. So it's pushed the market to the wrap up concept. And when you look at the list of insurers that provide quality insurance coverage for residential construction on a wrap up basis in California, it is extremely short. So there's not enough market competition in the state. It's driven rates to be incredibly high, still not seeing the profits on it. And the insurance is ultimately there to benefit the consumer, because when these projects are built and there are construction defect claims, the insurance companies of the builder are really the deepest pocket of what's then funding the repairs.
So is it
So
hopeless, or is it kind of turn around, and how long?
I think it can turn around. If we say the bill passes soon, and going forward, all of these things are implemented, you've got, call it 1 to 2 years, maybe 3 years, as you start to see projects coming out of the ground, getting built that fall under the requirements and the guidelines of this bill. From there, call it at least 2 to 4 years before you start to see, some construction quality concerns coming out of those projects. And after that, it's at least another year to probably see some of these concerns addressed and hopefully upheld in the California court system under the new guidelines of 1903. So right there, we're looking 4 to 6 years out to start to actually measure the benefits of some sort of reform passing. So it creates a couple of big questions on, well, what happens for the next 4 to 6 years, given the direction of the insurance market, continuing to become more and more unfavorable. And if we're going to have to wait 4 to 6 years to see if this is going to produce the results that might allow for the savings to come down the line back to the consumer, it's a pretty long horizon before I would say the insurance industry actually looks at the market any differently than it is today, because it's not going to be there's change, let's get back in. It's there's change, let's see how this works. And once we have confirmation that the capacity that's being deployed actually has some protection around it, I don't think we're going to see a change in the insurance industry.
So you're saying that decreased insurance premiums just from the bill passing are unlikely. You want to see real evidence. Is that how you're pricing your policies?
I would expect that the insurance companies that are participating in the marketplace now would would have comfort from the bill passing and potentially stabilize that. I would be surprised to see many new participants coming into the market just due to the passing.
Okay. Tim, what were your thoughts on that?
Yeah, I mean, I think it's a couple different things, right? With 1903, right now we're, I don't know if we're early on in the process, but I'll let the more policy focused folks, weigh in on that. But obviously, typically the bills are signed August and September, so we're probably still 5 or 6 months ahead of that. If in August this thing looks like it has legs, I would expect to see a flood of notices to builders served on existing projects so that people can get in under the wire with their current format. So that's one thing to be aware of, right? Sorry to all my builder clients out there, but we may have a busy fall. Second thing would be, as those changes go into effect going forward, the implementation on the legal side could be pretty quick, right? In terms of creating these new requirements, and there's going to have to be some change as lawyers learn and behaviors change. But I do think that those restrictions going into effect and kind of creating these tighter rules, that does happen quickly, right? If we're talking about a January 1st implementation.
Your understanding it would impact projects that had already been built or only projects as they come out of the ground?
My guess would be that this would happen, basically projects that have not yet served a notice to builder would be operating under the new system, and those with the notice to builder pending would get to operate under the existing system for those requirements that were in effect. So that'd be, that's one question, I guess, for the authors and for us to consider as we go forward, is making sure that that's clear.
All right. Well, I've been watching the chat and trying to incorporate a couple of the questions that came in, but I want to go to more open Q&A. But real quick, last comment from Mia. I want you to kind of close this section and just talk about what what you think this can do for production, condominiums, small lot homes. How is this going to help us with our housing crisis?
Yeah, well, I like to be the optimist because I'm a developer. And I do think this is going to make a difference. I think it's going to shift the paradigm. I think if AB 1903 is enacted, I think it will move the needle with builders who are struggling right now to figure out how to make their projects pencil. And if we can get certainty around risk, be able to control our liability and our costs, I think we're going to start to see more people come into the smaller sort of infill lots where we can have, take advantage of some of the streamlining. I think we're absolutely going to see it when people are looking at adding ADUs and trying to sell off ADUs and do, condominiums. I think we're going to begin to see potentially, more private investment in multifamily construction for sale. I think this is where I see the needle moving. And I know it's going to help, pretty much for sale across the board. But where I see this making it a significant difference is when we're looking at, higher density housing, especially when we're looking at our transit areas and all the things we're overlaying to create density. Right now, the only thing that begins to pencil is like 10 units to the acre. subdivide a single acre into 10 lots and try to build a house in an ADU when that could be 40 units, for example. So we're already seeing this happening. It's playing out across the state where we're undersizing developments just to fit into whatever box it just basically makes sense. So, we're moving, even though we have these incentives to create density, we're doing absolutely the opposite, because the only thing that really pencils are large single family homes or townhomes. And so I think when we have an opportunity like this, I'm hoping that we'll drive a truck through it, that we'll be able to start to see more production because, I think it's really going to bring more people back into the market that, have been sitting on the sidelines. So at least that's our hope. And hopefully we can start to see our land use policies begin to catch up with the fact that this is the missing middle housing that folks have really been clamoring for, I think. And the other, I think, beautiful thing about this too could mean that maybe there is less subsidy that needs to go into these for sale products, where the market can start to deliver these products without the kind of deep subsidies that we are sort of accustomed to see. And that maybe we can begin to unlock some of the tools that we have, like enhanced infrastructure finance districts, so cities can get into the business of building infrastructure, not putting it on the backs of every single developer who's trying to build housing. And, we can start to begin a functional system. And frankly, what it also does is we're seeing a lot of suburban areas that have transit and, declining enrollment in schools. And, you have big houses, but only older folks that are living there. I mean, you start to begin the shift and we need it. We need it for our population. We need it for our growth. We need it for our workforce. So anyway, I'm hoping this gets us more home ownership, which increases our tax base, which increases stability for California. So optimism.
Yeah, I think it would be great to see more folks get into business of building condos, right? I think people believing that. One of the things that came up in our research over and over again is the number of projects that start as condo and end as non-condo, like something crazy, like 90% of envisioned condo projects don't end up getting built because they get changed because they can't find an architect or engineer who's willing to work on condos, or they can't come to an agreement with the GC because the amount of insurance that they can afford to buy is less than they would be able to afford to buy on an apartment project, or et cetera, et cetera. I think we had one comment saying, what's the impact on an owner, a condo owner, of like 5 years of litigation? I'm not sure if they're talking about the developer, the owner, but litigation is just a mess for everybody involved. It's expensive. Stephen talked about the high self-insured retentions that condo developers are having to hold. Creates a lot of challenges for sure. I'm gonna try to get to a couple of these other questions. There was a specific question about pieces of the bill that addresses HOA member voting. I don't know if Mia or Nick, you guys know about that one. If there's a threshold, increasing a threshold around HOA votes.
I'm happy to talk about that, but I did see Tim's hand up. But
Tim, did you want to add a comment before we go to that question?
Yeah, I think the comment, at least what I saw in the Q&A, was that someone had asked about what's the impact on an individual homeowner when their neighborhood or their complex goes into litigation. It's a good point, and I think it's the same thing you made earlier, Thomas, that not being able to buy that home, not being able to sell your home, having to disclose, right? I frankly think, in my experience, dealing with some high-rise, luxury condo projects, bringing that to the attention of the homeowners and saying, hey, by the way, now that your entire complex or your entire building is involved in litigation, you need to now disclose that the next time you go to sell your $2 million condo. That, hey, by the way, here's the long list of defects that are involved, that are alleged to exist in this building. And I've even gone so far as to take the depositions of individual homeowners, and say, hey, I understand your home's currently on the market. How's that going for you when you disclose all these things? Oh, well, none of those apply in my unit. Okay, well, thank you very much for that. We appreciate that.
Wow. When I was surprised but encouraged that Stephen thought that just informing HOA members and homeowners about some of this stuff, you actually think it could be impactful. So it's great to hear.
do you want me to address the voting?
Yeah, Nick, the HOA question, go back to that.
I mean, really what that comes down to is that the individual unit owners are not aware of what's going on, and they're not informed of the potential downside to what's being done. all of which is to say that there's a certain minimum level of information that they should be provided with, good and bad, about making a claim, the process, how long it takes, and what it's going to mean for their property values and their life impacts on their lifestyle and the time that's going to be taken from them in order to deal with these issues. And all of which is important to us because, again, what we're about is deciphering the real claims from the fake claims. If we could just do that, that would reduce, I think, a lot of the costs involved here.
Thanks, Nick. Tim, I think this question goes to you perhaps, or maybe Nick. Does the bill address or require homeowners to go through a pre-litigation pathway before bringing suit?
Yeah,
Yeah,
there's
I mean,
go ahead.
go ahead, Nick.
There is a specific provision that says every claim has to go through this process. There will be some necessary adjustments to other language in the law in order to effectuate that, I think. But the concept is every time you make a claim, it should go through this process before you can go to court.
And I think that's necessary, and frankly, I think that was the way that SB 800 was set up. It just ended up getting bypassed a lot of times, where people would go to court, file their lawsuit, and then stay the action while they went through the SB 800 process or skipped over it. I think, by the way, for a lot of our bigger builder clients, where they have true homeowner issues that are observed in units, I think Mia made this point earlier, those get fixed, right? There are active warranty programs where a homeowner sees something in their unit, they call the builder, they have a hotline to call, right? The builder still, goes out and fixes those things and addresses them. And so there is an element of kind of nip that in the bud, customer service, warranty issues. Granted, there's probably a wide variety of responsiveness in the market, but I think certainly for the larger home builders, for the larger condo developers, there is a goal of keeping those customers happy because they want them to buy another home from that same company in the future. And you want to have your reputation protected. So I think that system already exists and hopefully will continue to exist.
A question related to the builder's ability to address repairs. And this question is that right now, in some insurers will actually push back on providing coverage for actual repairs, and they will require a lawsuit to be filed to meet the definition of a claim. Does this bill, is there a way to change this dynamic, or does this bill potentially fix that issue? Stephen or Tim?
Yeah, from an insurance perspective, a lot of the times when you see an insurance company delaying moving forward with settling a claim related to construction until a lawsuit is presented, it is using that lawsuit as the ability to bring the subcontractor's insurance to the table from a subrogation perspective. So in that scenario, we've completely moved away from condominium construction because you don't have subcontractors bringing their own insurance to the table in a condominium construction project. It's going to be almost exclusively, underwritten via a wrap policy. And when you move into a wrap policy and you look at the, 4 to 6 insurance companies that are providing the majority of the wrap-up insurance coverage in the state of California, these are carriers that have relatively broad insurance coverage and quality insurance companies that have proven that they stand behind the language of the insurance policy. So where there is a true defect in the project, I don't expect this bill to change the availability to trigger coverage really at all. It's not about taking rights away. It's about realigning the incentives so that the system is paying for the repairs versus the escalation, and focusing in on where we have the property damage versus feeling the need to leverage the rest of the project and the rest of the subcontractors to be involved in a construction defect litigation, to have a very long list at the end of the day, like Tim has talked about, of all of the alleged defects that then do have to be disclosed if you're trying to sell a unit. And the likelihood of using repair dollars to actually go make repairs on this huge list of claims is extremely low. So if we can get the insurance dollars back to focusing on repairs, I don't think that you're going to see the games being played in the practice policy market, trying to get the subcontractors to the table to deal with defense costs. And it's really, you're trying to trigger the additional insured coverage, and you're trying to get somebody else to pay the defense costs. If you're just looking at, we have issues on a project that are property damage or bodily injury, it's a bad faith claim if you're not responding to these. So I don't see games like that being played in the industry. It's more around triggering defense costs and trying to figure out who's going to cover those bills.
I'm going to pretend I understood all of that, and we actually have to we have to wrap up. And I'm going to turn it over to Michael Lane from Spur, who's our special guest, to close us out and give us a nice summary and tell us about his upcoming webinar where we can answer more difficult questions about construction defect
Right
liability.
to repair. That's all we ask for. Thank you. Excellent, outstanding group of panelists here. LAI has been an outstanding partner with us as well, and helped to actually fund the survey that Thomas undertook for us and the Turner Center to really begin to dig deep on the insurance piece. Next Tuesday is the moment of truth, the big day in the Assembly Judiciary Committee for this hearing of AB 1903. They've actually got 40 bills on the agenda, and so they're going to start at 8 a.m., which is relatively rare, but they're probably going to go for most of the day, which during these times of the year that tends to happen in the Judiciary Committee. So you're able to follow online or try to attend in person in the state capitol. We've got a great broad group of supporters from across the state, local jurisdictions, big city mayors, as well as professionals who would like to build condos and design them, et cetera. So we feel really good about that coming together. Business groups that have rallied has seen a really important way to provide that affordable home ownership for our workforce in the state. As a follow-up discussion, and kind of we'll debrief that committee hearing for a webinar that we're going to be holding with some of our other partners on Thursday, May 7th from noon to 1. Next week we'll have that. It's a free webinar. We'll have the link for registration available on the spur.org website next week. And Assemblymember Buffy Wicks will join us too, and hopefully we'll be able to celebrate passage of the bill through the Judiciary Committee, talk about next steps, and we're also going to take a look at Colorado and talk about some of the reforms they were able to accomplish recently and how they might compare and contrast with what we're trying to do here in California and get some of their insights on how they accomplish their reforms as well. So with that, I'll now turn it over to Rick to close us out.
Thank you very much, Michael. And Sheila, you can put up those slides. I'd like to thank everyone for attending today. It was a great session, and I'm looking forward to attending on the 7th and to hear from the Assembly member and also from the experience of what jurisdictions are doing right to repair better than California is right now. And for those unfamiliar with LAI, Economic Society, this first slide shows resources of events that we've done. Michael mentioned one of them, both on housing affordability and construction defect law. Other slides are providing links to LAI, Land Economics Foundation, and our LinkedIn page. And as Sheila said, please take a few minutes to complete our survey at the end of today's event. This really helps us in terms of understanding what else we should be doing. So with that, close out and thank all of the panelists. It was an excellent presentation and met all of our educational objectives that we seek to in LAI. Thank you.
Thanks, everyone.